Hello and welcome to the E-Pathshala course on intellectual property rights. I am Yogesh Pai, Assistant Professor of Law at National Law University, Delhi. Today we are going to discuss a module on fair use or fair dealing in India. This module will provide an overview of conceptual issues surrounding fair dealing, the rational basis for fair use of fair dealing and including their limitations, the nature of section 52 which talks about fair dealing in India and conceptual issues surrounding fair dealing. Fair dealing in India will look through some cases decided by high courts and the Supreme Court. We will look into musical works and fair dealing of musical works, what qualifies for review or criticism, whether time factor is essential in case of fair dealing, whether there is a de minimis exception, that is a standalone exception other than fair use, and how do we distinguish between fair use and de minimis, the scope of criticism or review, and fair use or fair dealing of cinematographic films and sound recordings, and post the amendments, what is the scope for fair dealing of remix uses, and we will also discuss the recent DU photocopying, Delhi University photocopying case that is currently ongoing. Finally, we will end up with a brief summary of issues. Now, if you look into issues around fair dealing, we need to discuss a bit on why fair dealing. Primarily, copyright is an instrument to incentivize creators at the same time to create a public domain, vibrant public domain of ideas and expressions. However, since you are giving a property kind of monopoly, there is a dead weight loss on the society, and hence it is a second best solution to the problem of incentives, which means that it would require several balancing factors. Fair use or fair dealing is one such factor. Apart from fair dealing, there is idea expression dichotomy, wherein basically copyright law provides protection only for expressions and not for ideas. However, at times you may also require, in larger public interest, the use of expressions. So, in such cases, fair dealing acts as an exception to infringement. Now, if you look into the underlying basis for copyright and the relationship it shares with fair dealing, it primarily revolves around 4 or 5 factors. The first factor is free speech. One of the important reasons why copyright is being granted is that it is also an expression or engine for free speech. At the same time, it also tries and protects or provides monopoly in the expressions. So, how are you going to balance out the incentives for others to take speech from elsewhere and include it their part of free speech? So, fair use tries and articulates this premise that the underlying basis for free use of expressions from earlier works to a limited extent should be allowed under the law. So, free speech is one of the important factors why fair use exists under so many acts across the world, copyright jurisdictions across the world. Second is the public domain of ideas and expressions. Now, if idea expression dichotomy is considered as the single most important factor which allows others to freely use ideas, but yet use of expressions is important, it is also because by virtue of expressing ideas, there is a vibrant public domain of future ideas that is created, and the public domain that is created by virtue of fair use is equally important. Third is the ease of access. There must not be many structural impediments to access prior works. So, fair use creates that kind of formula which offers a wide variety of users to have easier access so that there are no structural impediments. Finally, fourth is affordability. One of the reasons why fair use also exists is that certain uses are treated as free uses, and hence such free uses are on account of the fact that a larger section of the public, for a larger section of the public, these works must be made affordable. And then finally, we have issues concerning authorial integrity, wherein although there are fair uses that is allowed for the larger section of the public, at the same time the way it has to be balanced with authorial integrity and with incentive for creator is paramount in determining fair use from a conceptual perspective. So, the need for fair dealing ultimately boils down to one of the most important principles of public interest, that is access to existing ideas and expressions. Now, the essential core of property right and if you treat copyright as a form of property right, then the right to exclude and the right to alienate should not be interfered with. However, fair use directly interferes with such a right by way of creating what is called as a liability rule. In the liability rule, the value of entitlement, including the right to determine whether someone else should have access to your works without your permission, and the value with reference to what compensation you should derive, is decided by a third party. So in liability rules, market is not determining the value of the entitlement, but a third party is determining. The case of fair use is a case of zero liability rule, wherein no compensation is provided for accessing works. So there can be uses with compensation, which are in the nature of compulsory licenses or statutory licenses, and there are uses without compensation, which is largely fair use. Fair use is thus a zero liability rule. Now, largely fair use across jurisdictions has been based on 4 factors. One is the purpose and the character of use of the work. Second is the nature of the copyrighted work. Third is the substantiality of portion that is used in relation to copyrighted works as a whole, and fourth is the effect on the potential market for or the value of the copyrighted work. So based on these 4 factors, courts usually determine what amounts to fair use. Now if you look into the rational basis for having fair use, there are certain issues that come to that are to be discussed in this context. First one, would there be fair use when there is a possibility of an existing market for a license, and whether existence of mere market for a license deviate from fair use? There are both sides of scholarly discussions around this issue, wherein existence of a market for license need not deviate from fair use, in the sense that mere showing of a market should not mean that there is no fair use. In that case, what would have happened is, because it is now possible to license each and every kind of activity that users would otherwise have it freely under the broader fair use paradigm, it would mean that no such fair use should exist, and that is the reason why existence of a market for license should not be one of the important criteria to assess whether fair use or fair dealing should be provided. Secondly, fair use does not contain use of existing works as they are, but fair use enhances transformative works and transformative uses. So what is important to consider in this context is the balance of incentives. It is not just the original copyright creator or the author who should have a final monopoly on the future works that are created by virtue of the first work, but there should be a balance of incentives for the society to create more transformative works through transformative uses. Now, what is also important in the context of fair use is, fair use vis-a-vis infringement is decided at a point of time when there is a legal contestation. So until then, there is no conclusive proof whether an infringement amounts to fair use, or whether it is actually within the scope general purview of infringement. So in that case, the market power that is conveyed by copyright law by way of an injunction is very strong, and that is why there are certain issues whether injunction should automatically be issued, primarily preliminary injunction should automatically be issued, where a defense of fair use is being taken by the defendant. Furthermore, should the existence of a license, in the sense that bringing down the transaction cost, disentitle us with fair dealing or fair use? This is very important in the context that prior to the internet, the argument was that seeking a license in each and every case would raise the transaction cost, and now if by virtue of the internet it is possible to license on a mass scale and bring down those transaction costs, which means now a potential market for a license exists, then, and by virtue of the bringing down the transaction cost, fair use should be diluted. Now this particular issue has also been debated for long. Finally, fair use and fair dealing, whether it should be considered as a right or whether it should be considered as a mere defense, is also one of the contentious issues that is being discussed almost in all jurisdictions. And lastly, by virtue of criminalizing copyright, and all copyright jurisdictions are expected to have criminal measures at least where copyright piracy is on a commercial scale. So, in such cases, if criminalization is not just about piracy, but extends to infringement in individual cases, will there be a chilling effect on fair use is also an important factor in deciding how far fair use helps actually in generating free speech and works as an engine of expression.